Okay. Hi, everyone. My name is Manley Sitter. I'm VP Education for ASCM Western Canada. Going to introduce to you today Andrew Duran, based out of Calgary. He is going to be discussing when procurement meets legal risk. I'm going to hand it over to Andrew, and Andrew, please go ahead.
Thank you, Manley. Hi, everyone. My name is Andrew Duran on behalf of ASCM Western Canada chapter. We welcome you to today's practical session, when procurement meets a legal risk, and specifically, what should supply chain professionals need to know about their contracts. So, as most of you, I'm already thinking, work with contracts every day. This is not going to be a law lecture by any stretch, but rather a practical session to help you see what's actually at stake when handling these sort of documents. So just as a bit of a background, I'm an active member of the Law Society of Alberta. I'm also registered with Ecuador's law forum managed by the Judicial Council there. I hold Canadian degrees in both business and law and several years of experience in various procurement roles, all the way from purchasing to contract management for a large buyer, a mid-size general contractor, consulting subcontractor, as well as a few public entities. So I've been sort of like in various stages of the procurement process, both as a supplier, both as a contractor, both as a client, and I sort of like have been able to see how contracts are looked at in a different aspect. And currently, I'm a legal counsel and corporate secretary for Innova Geophysical, a global seismic technology manufacturer with a legal practice focused on commercial, corporate, international business, intellectual property, as well as compliance. So just as a general disclaimer before we get started, this is just everything that's said here is general information for educational purposes only. Nothing that I will say constitutes legal advice for your specific situation, if you have any. And if any contract issues arise within your workplace or your organization, please engage with a local lawyer for legal advice based on the facts that may apply. So with all that legalese aside, I just want to jump directly into today's session. So today's session will focus on why contracts matter in the first place. Is it more than just paperwork? And obviously, what's the most common weaknesses that tend to arise when dealing with contracts? Also, which situations create the most risk? What are the consequences to look like in practice? And last but not least, a sort of checklist that you can take with you when considering reviewing contracts, if that's within your scope of your role. So why are contracts important, or why do contracts matter? So by the time that I started putting together these slides, that's the first question that came to my mind. Why would you care? Why would contracts be something that a procurement or supply chain professional even take time to look at? So it's something that I understand that again, most people don't take too much of time to look into, but in essence, contracts are more than mere formalities. They're actually operational tools that are used in order to make the business proceed, the transaction come to an end, make sure that everything's in paper, so to speak. But however, how many times in a procurement situation, in whatever role you're at, has a contract led to a dispute, either as a buyer or a supplier, in your lifetime? Like, it's likely more common than you think. An example that comes to my mind is when payment terms are not clearly triggered. So I'll give you an example. If you have a contract that says net 30-day payment from the invoice date, that seems clear enough, right? Or does it? Because invoice date could mean from the time the invoice was actually issued, from the time the invoice was received by the other party, in this case, the buyer received the invoice from the supplier, or from the time that the invoice was actually approved by the buyer. So there's all these little little fine print that you can't possibly foresee at that time, but can lead indeed to these sort of issues down the road. So based on that, my second, or I guess the second part of this session is focusing on the common contract deficiencies, meaning the most procurement contracts fail in one or more of these areas. Rarely I've seen a contract fail in all four, but in most cases, any of these can lead to serious consequences. So to start off with that first, one of the first topics there, the vague commercial content. And this might involve scope of work, meaning what's this contract about? Like, is this something that was clearly articulated and established from the get-go? Is this, are the deliverables set in stone? Is the acceptance criteria quite clear before the buyer is legally obligated to pay their supplier? And even if it is the supplier able to action such obligations within a contract? What about payment terms? What about pricing? What about shipping terms? And let's not get even involved into Incoterms, which again would take another hour just to go through. But for the most part, it's dealing with all these sort of commercial, for lack of a better word, terms that tend to be embedded into a contract either by a sales or business development department or operations department, depending on what it is. And then it's transferred to the other side. And then unless there's that clear understanding what one of the elements of a contract, if you've ever taken a business law course, the meeting of the minds, like the offer and consideration, and there's a clear understanding of what you're offering as a supplier versus what you're getting as a buyer. But if that's not the case, then how can we see in reality how a scope of work, a weak example of a scope of work would compare to a strong example? So this is an example that I just put together based on what I've seen in my own practice. So a clear example: the supplier shall provide services as required. Bold and simple, right? But then you do realize that there's no clear understanding on what exactly are services, what should be understood as services. So that's where you get the defined terms within a contract, right? What you see there between brackets. When is that going to be provided? In what sort of format is that going to be provided? Is it even included in the contract? Because if it's not clearly established, at times this may lead to a lot of issues down the road. Now, let's look at another example of uncertainty or terms that might lead to confusion down the road. Pricing, which again is something that most supply chain professionals tend to deal with in one or another way. This is something that came post-COVID due to the volatility of again, everything. And depending on who you represent, it's going to look very different, right? So if you look on your left of your screen, you're going to see a price escalation clause that's going to be favorable to a supplier, in the sense that anything and everything will fall under that clause, and therefore they can jack up the prices, right? And sometimes it's fair. I mean, it is what it is. Sometimes there are increases that are beyond their control, but sometimes not having a way to track to govern how prices are going to be increased within a given period of time may lead to a lot of issues down the road. And then you can see on your right the same idea: price escalation from a buyer's perspective. As a buyer, you obviously don't want anything to change. You want to lock in those prices from the get-go, so you have a certainty of how much you're going to be paying over the time frame of this contract. That being said, that's not bulletproof either, because if you negotiate a price escalation or fixed prices within the term of an agreement, chances are the prices that you're going to get offered already account for that for any potential escalation down the road. So it's a double-edged sword, but at the end of the day, these sort of clauses tend to create a lot of issues down the road. Now, continuing ahead on the unclear terms and conditions. This is more of a legal side of things, so I'll explain what each of these this terminology means for those who don't know. So the first one, battle of forms, which is again when a buyer would send their own terms and conditions included in a PO to purchase something, right? And this is after the seller sent their quote, and their quote has their own terms and conditions. And you would think that's the end of it. The supplier got a PO, might as well just bite the bullet, accept it as is. Well, depending on how desperate they might be, they might accept it. Sometimes they won't. Sometimes they'll still push back because who knows? Maybe depending on their risk tolerance level, they've already been burnt in the past, and they've realized that accepting anything and everything just for the sake of attaining new business might lead to unforeseeable risk that could bankrupt any organization. So in most cases, that's one of the things that shows up the most when dealing with procurement contracts. But just as a bit of a background as it relates to unclear terms and conditions, there's a quote here that I got from a U.S. lawyer who I really like a lot, and he has a manual on contract draft, and his name is Ken Adams, and he identifies in his textbook 6 sources of uncertainty. So obviously ambiguity, undue generality, inconsistency, redundancy, conflict, and vagueness. So all in all, it's the same idea. If it's not crystal clear for both parties, then chances are it's going to lead to problems. So the other things that you probably see on your screen right now is warranty terms. Again, depending on whether you're a supplier or a customer, that's going to be quite important for you to stick with what you have on your limited warranty terms and conditions, or if you're a client and you're big enough to have your own expectations regarding warranty, making sure that warranty and any repairs in the product that's repaired or replaced has additional warranty for the same amount of time that's allowed. All that again governed under whatever the contract allows for, and any potential regulatory requirements. Insurance requirements is the same thing. Sometimes insurance tends to be a catch-all way to try to mitigate a potential risk in a contract, but also termination and survival clauses, because you might terminate a contract, or a contract might terminate, but some clauses might still survive, might still be in place, among them confidentiality, IP rights. There's many ways that a contract could still come back, and the way I see it, it's almost like the gift that keeps on giving. It never ends. There's more things and more things that may arise in a given contract. Again, I'm just talking very generally, but back to the battle of forms scenario. Here's a quick example of what I was just explaining a moment ago. So buyer's PO terms and conditions. You can see on the left, same idea. This is what you would normally see on a buyer PO. This actually comes from a prior example that I dealt with quite recently, where again, this is what I saw from a buyer's perspective in the PO included as part of the acceptance language, where you can see that this would override any potential terms and conditions that are different or somehow would change or modify any sort of obligations and rights and whatnot. But from the seller side of view, it's the same idea. Like if you're a seller, you're going to try to protect yourself and not blindly accept any terms and conditions just because it's the client. You still want to have a chance to review them. if you have the capacity to have an in-house counsel, have a legal look at it. And at times, I've met many people who, even though they're not lawyers, know quite a lot about these sort of clauses and are able to negotiate without any problems, to the point that they feel that they've met their risk matrix. So again, it becomes a battle, so to speak, because there's the various theories from a legal perspective, especially here in Canada, with the exception of Quebec, where a last shot rule is commonly applied, meaning the one that last sent or acknowledged the contract, those terms and conditions would apply. Meaning, again, if you're not careful with what you accept, even if it's just acknowledging a receipt, if you don't clearly state that you're reviewing the terms and conditions, you might be on the hook for many things that you probably didn't wish for. But then there are other rules that may apply outside of Canada, outside of Quebec. For example, in the United States, France, Germany, they tend to use a different sort of principle, which is called the knockout rule, meaning that a contract is considered valid even where offer and acceptance do not perfectly match due to different general conditions. So in this case, what is common is the substance in general conditions of both seller and buyer. Obviously, that might lead to a much more interpretation in terms of what each party meant and whether it's reasonable to hold one party liable for whatever scenario the last terms and conditions applied out. But at the end of the day, rules apply differently depending on where you are. And a clear example is a less popular principle that I learned is applied in jurisdictions such as the Netherlands, where it's the first shot rule, meaning the first party that sends their terms and conditions that contain or govern the transaction tends to prevail over subsequent ones. So you never know, and that's why you need to obtain proper legal advice when entering these sort of transactions, because you might think you're covered under your own PO terms and conditions, but you might not. It just depends on many other aspects. So going into another way that contracts could become an issue is having weak indemnity and remedies, meaning there's not a clear understanding of what gross negligence, willful misconduct is. The two, like, again, there's a distinction between whether there's an intentional wrongdoing or not. But at the end of the day, these tend to require the involvement of legal counsel. Limiting liability is another clause that tends to get looked at and pushed back, especially within contract reviewers, because you obviously want to make sure that when you sign a contract, there's some sort of limit, a cap to whatever can be limited, if not prohibited by statutes or any governing law. So in this case, the limits that I've seen and I've negotiated in the past could be related to all the way from a specific arbitrary value. It could be tied to the proceeds actually obtained from insurance coverage. It could be tied to many things. Like it just depends on what is reasonable. And at times, big corporations, being so sophisticated in their terms and conditions and the leverage that they have, they tend to use their forms, their templates as adhesion forms, meaning take it or leave it. These are our terms. It's almost like trying to go and negotiate better terms with a cell phone provider. Unless you're their size and have some leverage in that negotiation, chances are you won't be able to change any of those terms and conditions. That being said, there is a sense that you have to negotiate fairly. You have to give the other party a chance to provide their own take on what they think is something that they would be willing to agree with. So another aspect that I also want to address in this portion of the indemnities and remedies is consequential damages. So it's almost like agreeing on doing a $20,000 job on a site, to give an example very tied to Alberta's energy industry. So think about that, a PO that's worth $20,000, but because there wasn't any specific waiver of any consequential damages, and you are a supplier, and you're on site, and you have a truck, and for some reason you end up causing property damage, and that damage ends up costing millions of dollars worth of losses to the client and potentially other entities. Well, if you have no waiver of those consequential losses, damages, even foreseeable or unforeseeable, you might be on the hook for those as well. So it's quite scary, so to speak, and that's why I think this is one of the examples that I can bring to the table here, which is again just a general mutual waiver of those consequential damages that tends to be accepted in most cases, but by most parties, unless again it's a very specialized project or scope of work, and that for the most part tends to avoid those sort of scenarios. Now, as it relates to the last aspect of what can lead to contract deficiencies, we have uncertain dispute resolution mechanisms, right? So how many of you have been in a dispute that has escalated to formal arbitration or litigation? Probably very few, because that tends to not be even dealt with at the stage of procurement or supply chain. It tends to happen down the road after a contract is done, after everything's sealed and passed on to another area. But unfortunately, not every contract is the same. Contracts, there's no standard contract whatsoever. Like there might be industry standards depending on the industry, but there's no one standard for POs or whatnot. It just depends on what parties are willing to agree on. So in this case, when it comes to dispute resolution and how to deal with claims, how to deal with breakdowns in communication, without a ladder, without having a clear mechanism on how each claim is going to be escalated. Is it going to be first dealt with through direct negotiation, which should be by far the fastest and cheapest way to preserve that relationship, sitting in front of like in a table and just trying to sort things out? What about mediation? Having a third party, a neutral third party, come in and help parties reach some sort of agreement, right? In most cases, it's non-binding. It is private, so you avoid the public scrutiny of having your issues ventilated in public. But at the same time, unless it's stated in the contract, it's just going to depend on the willingness of the parties at stake. Then if you're lucky to have a contract that has an arbitration clause, arbitration clauses are not all the same. They have to be very tailored, very specific in order to be applicable, right? So even if you have a contract that defers any potential disputes towards arbitration, that's fine. But then, is it the right venue? Is it the right rules? Is it the right governing law? How many arbiters? What language is it going to be? Is it binding? Is it not binding? What about any remedies? Can they still use the courts? There's many things that tend to go on when it comes to arbitration, and that's where again having a proper legal advice, having somebody that knows exactly how to tie those loose ends in a contract is worth approaching, right? And last but not least, obviously litigation, plain and simple. going to the courts, it's expensive, it's slow. There's a lot of red tape around all the different stages, and it's going to depend on the governing law and the venue. So not all litigation is going to be the same depending on the jurisdiction. And say, for example, if it's a transaction that happened between parties in one location, but suddenly the venue, the governing law is not even neutral, but it's more convenient, at least towards one party, then you might end up as the other side, spending more time and money and resources hiring external legal counsels to deal on that front for you, right? And keep in mind, lawyers charge by the hour. It's very, very cost prohibitive for most organizations to go through an entire litigation process. And even if they do, in most cases, they end up settling. And that was one of the things that I was surprised the most when I requalified as a lawyer, realizing that in Canada, at least, most litigation in the commercial sphere, at least, tends to settle before leading to a court decision. And the reason for that is because at times parties need to quantify, need to size up the other side, need to understand how strong their arguments are, how strong their evidence is, so that if it comes to that, they have a better sense of like how much can we actually end up settling for, right? How much should we end up just coming to a conclusion or not? Now, if one of the I guess the code of conduct, at least here in Alberta, and it's similar in most provinces, has puts the onus on the lawyer to provide any potential settlement opportunities for their client to consider. So if there's a settlement opportunity ahead that can be seen, it can be possibly an option, it's in the interest of the client and that lawyer, as it relates to the loyalty and keeping the client's interest first, to let them know that there's this opportunity to settle for this amount. And in most cases, it probably makes sense to settle something before you go through the entire show, because in most cases, unless it's really, really high stakes, it's a matter that needs to be ventilated in courts. Parties don't want to go that way. You end up being a case law example for many law graduates for the foreseeable future. So in most cases, companies tend to prefer other alternative dispute resolution methods. So I see we're approaching 30 minutes, so I'll continue to the next stage in our presentation, which is, again, what high-risk scenarios should you as supply chain professionals keep in mind? So again, I won't go into full detail into all these different legal terminology. There's one that obviously I do think it's worthwhile talking about, which is privity, meaning only the parties that are part of a contract can enforce it. So this comes a lot into account when dealing with subcontractors, because subcontractors in an owner general contractor scenario are not part of that prime contract. They're under the general contractor, meaning if depending on who you represent, if you're the owner, you will want to make sure that main agreement, that prime agreement, includes some flow downs, one of the other terms that you can see on the screen. And those terms would allow or force or put the onus on the general contractor to sign future contracts with their subcontractors where they include and flow down some of those obligations down to their subcontractors. So it's sort of like it's risk. They're sharing the risk among an entire group of contractors, right? But the main clients can't force somebody that's not part of that main contract if it's not through the general contractor. So that's privity in a nutshell, right? Or the other example that I tend to explain say, for example, to relatives is, say if I agree that A and B agrees that C owes them money. Just because they agree, it doesn't mean that C is going to have any obligations to pay them unless C is part of that same agreement. So that's probably an easier example. Now, again, as it relates to these other issues, the other one that also comes a lot into play when dealing with POs and contracts and other aspects is implied or apparent authority, meaning do you have the authority to actually sign off on POs? Are you the legal representative of that entity? Do you have a limited authority? Do you have a power of attorney? Something that would give you some authority in order to sign off, to sign a PO. And from the other party's perspective, that's where this legal, I guess, definition comes into play, which is they don't need to really rely on you making sure to follow your internal guidelines and who can sign, but rather they start with that assumption that you have authority, apparent authority, implied authority. So as long as you demonstrate that that you're working for, and representing that organization, at least apparently, they could still have a valid claim against the organization. Meaning, somebody on site is presented with a PO from the client, and even if they are now by no means allowed to sign off on POs, if they go ahead and just sign off, chances are that might lead to legal consequences. Again, I don't know the facts, there are no the details, so I can't provide any legal advice. But in essence, those are the two things that I highly recommend supply chain professionals be aware of. The fact that parties have to be part of the agreement in order to be obligated to do something, and the fact that you have to make sure that the person that's signing off on contracts, POs, and whatnot have the actual authority, internal authority, whatever you call it, in order to proceed. There's the limitations period that any lawyer will tell you about, which again, depending on the jurisdiction you're in, here in Alberta at least, it's 2 years, and that limit allows a party failing to start a claim to have that time from the discovery of the loss to do so. Otherwise, they might be permanently barred from doing so in the future. So it's a two year up to 10 years, depending on, again, certain criteria that I'm not going to get into. But in essence, these are the high risk scenarios where in most cases you want to make sure that you consult with a lawyer. Now, going to the practicality of all this, like what's the real world impact? Relationships break down, meaning legal disputes are rarely going to preserve that relationship. The cost is not only legal fees, it's the trust, it's the disruption of operations, it's the time spent handling the dispute. And anybody and everybody that has ever gotten a parking ticket, let's not talk about anything serious, knows the stress and the toll it can take on you just to go to court to fight that parking ticket or whatever the case may be. So just imagine from a corporation's perspective having to deal with litigation for millions of dollars depending on the scenario. So it's definitely something that parties end up burning bridges if they get to that, right? Unexpected financial obligations, again, that idea about consequential damages of not understanding what's at stake, what you're on the hook for, or what you're signing off, even if you didn't have the actual authority to do so, and that you're putting your organization at risk. So many procurement teams discover this obligation only after deciding something else, right? Now, as for those that are more in the operations side of things, there's project delays, cost overruns. All that is again in part a consequence of the lack of clarity or very vague scope of work that was put in place in a contract, and that's why you see There's even a joke that I remember learning in one of my supply chain classes at the time, which was I think it was a photo of a little boat that was called somebody likely had a little boat there that was called original contract, and then they had a huge yacht, and that was the change order, right? And it tends to be, in most cases, accurate, right? You have a scope, and if you did not take the time to develop that scope, you end up wasting a lot of resources, money, and realizing that yeah, the supplier knows what they're doing. They exactly know how to get the most out of their business transaction based on what you forgot to include in that scope at the beginning, right? But sometimes it just doesn't depend on the parties. We didn't know what we didn't know, right? But in most cases, if you take that due diligence of sitting down with a proponent, if you're on the buyer side of things, and hashing out the details of an accurate scope of work, relying on prior precedents, meaning prior contracts that might have been signed already, that also takes a lot of heat off the table. Now, what about the practical list that I talked about earlier in the session? So we obviously have talked about many topics, which some of them are quite dry, so I'll give you that. It's not the sexiest of topics, but at the end of the day, what practical things can you take out of this session in your current role as it relates to supply chain management, right? So the first one is supplier pre-qualification. You want to make sure that supplier is pre-qualified, and that's obviously going to depend on the organization you work for, right? So many organizations, especially bigger ones, they subcontract that. They outsource the pre-qualification to companies that solely focus on that. So I remember when I worked for an oil and gas company, they had various platforms that dealt with that, right? And they forced their suppliers to join that platform, pay a fee in order to be qualified. And depending on the score that was arbitrarily produced based on that platform, they would be either green in order to issue any POs against, or red, right? And what do these platforms, or in general, what's this pre-qualification about? It's basically making sure that it's a legal company, it's up to date, they have their annual returns, everything's good and running. They obviously have adequate insurance coverage. They have a existing contract in place. Like, it could be many things to many people, but just in general, that's what I would think of as it relates to being pre-qualified. Now, what about capable? Obviously, you would have to figure out based on a sourcing strategy what capable means, whether you're going to be sole sourcing, you're going to be bidding out, and if you bid out, whether there's a criteria that's going to be developed, and if you want to invite or already have pre-selected vendors that you're going to offer or invite into whatever bidding process you're looking into. But at the end of the day, it's making sure you're dealing with somebody that's worth your time, right? What about the scope? Is the scope clear? Is it measurable? Is it something that's going to be ambiguous and lead to disputes? Or are the deliverables, timelines, and acceptance criteria something specific and easy to understand? Because nowadays, and going back to that US lawyer that I referenced earlier, the best practices tend to be to write contracts in plain language. Like, avoid all the legalese, avoid all the jargon that only complicates things. It doesn't really add value. So I'm really into making it as crystal clear, as a manager of mine once put it, just make it dumb enough for everybody to understand in one go. It sounds easy, but it sometimes, depending on the scope, it might not be as easy as it sounds. Now, what about termination options? What about risk allocation? What about allocation in the sense that who bears the risk if something goes wrong? what about the dispute resolutions, which we already talked about, alternatives of dispute resolution? What's going to trigger force majeure? This is something that we didn't even touch upon. Like, when does force majeure apply? And this is something that was really prevalent, especially during COVID times. But at the end of the day, there has to be a clear understanding on what could go wrong in a contract, because in most cases, something might end up going wrong, right? So with that in mind, let's see what else do I have here. Yes. So unless there's anything, I'm not sure if there are any questions, or in that case, I would open the floor for any concerns that the audience may have.
If there are any questions, you can type in the chat or come on, Mike.
So while some questions get asked, one of the things that I've been able to see both sides of the equation now, both as a supply chain professional and now as a lawyer. As a buyer at the time, one of the things that I would always be so frustrated was, why do lawyers take so long to get back to me? Like, this is so easy, just review this. Like, why do I have to wait a week or 2 weeks just to get an audience with somebody if it's an in-house counsel? And the reality now that I'm in that role is that you have so much on your plate. I wear so many hats, and at the end of the day, I'm just putting out fires everywhere and anywhere, because that's the role of a legal counsel. It's like almost like the last line of defense. So in most cases, legal issues arise when lawyers, or in this case, legal counsels, are involved when the issue happens, right? So it's probably a best practice to involve legal from the get-go when you're putting together a contract, when you have a doubt about whether this template applies or not. And templates, the way I see it, are just a guardrail that any corporation will use in order to protect themselves, because the templates are owned and updated by legal for the most part. And that way, as long as you stick with the current template in place, chances are you're going to be good. But in most cases, you won't be able to use your own templates. Sometimes clients, suppliers will push back, and that's where legal gets involved to try to deal with all those variances as it relates to terms and conditions.
Hey, Andrew, we have a question from Cameron. Can you explain the 2 to 10 years after contract closure where either party could make a claim to reopen the contract? Typical in Alberta is 2 years, as per the initial comment made.
Right. Yes, that's totally right. So thank you for the question. So I was referring to the Limitations Act. So in this case, again, it's totally right on spot on the 2-year deadline, which is the basic limitation period to start a lawsuit. But there's also a 10-year, what's it called here? So it's a ultimate limitation period, right? So it's a drop dead 10-year after the claim arose. Now, again, like, there's a lot of rules and a lot of case law regarding when does this apply, and whether the parties, if they're in a litigation of some sort, or one party starts a litigation matter or a claim against another party, that one of the options that the defending, I guess the plaintiff and the defendant, well, the defendant in this case would have is to submit or apply for a drop dead application, meaning based on this rule, based on when the claim arose, based on when the party knew about their losses or potential losses or alleged claims, they could have this their original the claim from that party just not considered anymore by the court, and this is based on this limitation period. So this is something that is quite critical and very important, even from a legal perspective to keep in mind. So any potential lawyer, even if without any engagement, so even if say a party, let's just talk very briefly, but even if a party goes to see a lawyer for a contract dispute and it does not engage that lawyer or retain that lawyer later on, the lawyer has that obligation to let them know, hey, based on the limitation period, you have X amount of years to start your claim, just so you know, right? But this does not apply equally in all places, right? So one of the things that I was surprised not too long ago was dealing with a matter in Texas. So in Texas, they have something called the tolling agreement, which is again an agreement to extend any potential limitations periods based on potential settlement actions that are being taken by the parties. But while that is taking place, they want to preserve their rights if the settlement does not falls through. Like if they still have to sue each other, they still want to have an opportunity to do so and not be prevented from doing so.
And we have another question, Adelia. What would you say are the key clauses you pay attention to when reviewing a contract? Top three.
Top three. If I have to choose the three, limitations. So limitation of liability would be my first one. And again, it's going to depend on who am I? Am I a buyer? Am I a supplier? But in both cases, a limitation of your liability would be adequate best practice to be mindful of. I would also keep in mind the governing law and the venue, because if it's a venue that's not neutral, that's really far away, and then if something goes wrong, it's going to take forever to get to an agreement. That might lead to need to push back. And last but not least, I'm struck. I would say also having a waiver of consequential damages, but beyond that, I would also think, depending on the scenario, that intellectual property rights and or confidentiality might be important as well. So it revolves around limits of liability, waiver of consequential damages, and depending on the scenario, the type of transaction, it could be either IP, confidentiality, or insurance.
Okay, great. Thank you. David has a question. At what point does litigation become unavoidable?
It becomes unavoidable when parties are not able to come to a fair conclusion. So going back to those I guess the step or the ladder that I was talking about. So even if it's informal, just trying to negotiate a way out, a way to settle a claim before it starts. If the parties are just too far apart, you're asking for 1.5 million and I'm on 750, and I won't be able to go up to, like, say, $1 million, and there's still $500,000 that I'm just simply not able to do so, then chances are that's where litigation might get triggered. Again, in one scenario, it could also be the limitations period. What if you're running very close to that limitations period? You want to make sure that you submit your claim, and not only submit your claim, you have to serve the other party, right? So that might take some time. So those are two scenarios where I can think that litigation is unavoidable. Another scenario would be when you're, say, a general contractor and you're getting sued by your client, right? So when you respond to your client, so you get sued, you're obligated, at least here in Alberta, you have 20 days to, I think it's 20 days. So it's a very short period of time to file your statement of defense. And you could, at the same time, also file a counterclaim, right? And include other parties that might be subject to or somehow involved in this claim, right? And that's where you would uh, throw everybody else under the bus, right? All your subcontractors end up getting into that same lawsuit because you signed agreements with them. If you were keen enough to have flow downs and specific conditions that would make them liable given certain scenarios, you want to make sure that you're adding everybody and anybody that has to be there in order for potentially you to be exonerated, depending on what transpires. So those would be the general scenarios where I would see a litigation happening.
Great, thanks. Cameron has another question. What trends are you seeing related to AI?
Oh, AI is changing how we do business, and as it relates to contracts, well, I have to say, like certain tools have a good grip on putting together good first drafts of contracts. Like there's no doubt about it. I do think technology will change the way law practice is going to be done sooner or later. I do think that even supply chain as a whole is obviously getting influenced and improved by this technology. But as it relates to AI specifically, I do think that there's a limit, right? There's a limit on what you can rely on these tools, but there's still the need for having a legal professional review a contract, right? No AI tool is able to provide legal advice. And not only that, but there's many cases of what's been known as hallucinations happening, meaning that AI tools, especially in the States, I think, and there was recently a case in Canada as well, where again, like there would be lawyers that would cite case law that doesn't actually exist, that was just produced somehow, likely meshing up language from here and there, and it's not fully reliable. So I'm pretty sure down the road that's going to get better and better and better. But for those folks that are, I guess, familiar with The Simpsons, there's an episode where Homer has this little I don't know, duck or a bird that just goes like this and taps on the keyboard. You still need somebody to hit enter. You still need somebody to provide the prompts. You still need somebody to review and negotiate something based on a specific case pattern. So I do think that it's just going to be more efficient. It's going to be less cost prohibited for a lot of parties. Some clients, I'm pretty sure, will be able to get away with just using AI for the most part. But again, you're taking a risk because it's not a lawyer, and even those platforms know their limits, and they will tell you, consult a lawyer, do this, do that. Only problem is that when you're the lawyer and you're using these AI tools and it tells you consult a lawyer, but you're the lawyer. No, who should you consult with? But in essence, I do think it's something that's here to stay.
Okay, and thank you. And we have Wiley's going to come on, Mike. He has a question.
Hi, thank you. So earlier in the presentation, you talked about like the PO, the difference in the conditions from the PO and the terms and conditions. I think you brushed on it, but like what would take precedence? And does it matter if we had already stipulated before we went to a contract what the order of precedence would be? So like my company, we clearly lay it out in our general conditions, like before we even go to a contract. It's like, hey, if we make an amendment, that's number one, then it goes general conditions, then it goes plans and specs. I'm in construction. Mm-hmm. Yeah, I guess so. When you have an issue where you have two different documents saying different things, what takes precedence?
Okay. Thanks, Wiley, for your question. You actually bring up quite an interesting topic, which is the order of precedence, which I didn't quite dive into. Again, this is just best practices. I'm not providing any legal advice on that specific scenario regarding your organization. However, order of precedence in most contracts lay out what's going to take precedence if there's any conflicts between the contract, the PO, the change order, the amendments, and whatnot, right? But what if there's no order of precedence? What's going to happen? So that's where that battle form occurs, and then it's probably keen to get somebody to look into. But if there's an order or precedence, that in most cases will be what most likely governs that transaction. Again, I don't have the specific fact patterns to provide an adequate review, but in essence, if there's a order of precedence, in most cases, that will be the starting point. I would, as a best practice, when I would deal with an order of precedence and a document that might go against that, I would make sure to tie that, say, for example, a PO back to the original contract and just say this PO is issued in accordance with contract number, whatever, and the terms and conditions that get automatically added within the ERP system to that PO don't apply, right? Because you don't want to have PO terms and conditions and a fully fledged contract. If you were keen enough to put a contract in place, you want to make sure that it's governed by just one set of terms and conditions. So if you have a contract in place, I think that's the way you would go about it.
And sorry, just to like clarify what you said in the presentation, like that PO and the difference in the terms and conditions, what stood? Was it the PO or was it the terms and conditions?
Oh, so in that case, that's if you would not have a contract, a prior contract signed with that specific entity. So if there's no contract in place, there's literally, think of it this way: pick up the phone, call a vendor, they send you a quote, and you send them a PO. And they respond to your PO saying, yeah, we agreed to with your PO, but based on our terms and conditions, that's the battle forms when there's no clarity of what's going to apply. But if you already have a contract that has an order of precedence, or even if the PO has an order of precedence, again, it's going to be dealt with on a case-by-case scenario. So unfortunately, I can't tell you what's it going to be because it's going to depend on many cases. But if there's a contract already that has been signed by the parties, and by signed I mean like wet signatures, e-signatures, like you name it, like one signature after the other, and it's actual terms that have been agreed to, then in most cases that order of precedence would apply.
Okay, thank you.
Great, thanks, Wiley. Cameron has another question. Any examples with claims that involve unions, dismissal of employees, or pre-negotiation for severance? I think that's a different topic, I would gather, right?
Yeah, that's employment law. So unfortunately, I'm not competent in employment law, so I'll have to decline answer in that respect.
Okay, and Adila has another question. What are the most common mistakes organizations make before the contract stage that end up creating legal exposure later in the supplier relationship? Oh, no, hang on. Oh, yeah, that's exactly it.
So let's see if I understand. So what do companies do that creates legal exposure?
Yeah, well, what are the most common mistakes organizations make before the contract stage that end up creating legal exposure later in the supplier relationship?
Well, there's so many things that I could talk about, but if I have to summarize them in 2 or 3 things, I think it's the corporate culture. If it's a culture that's based on processes and procedures, and they're very keen on like everything has to get approved and has to get vetted before it goes out, that's a good sign. Even though if it's way too heavily convoluted, it could lead to a lot of red tape and a lot of back and forth just to get a PO out the door. But it's also about training. If people don't know what they have to do when they get a PO that's not fully acknowledged, or maybe it looks like it's acknowledged because it says we acknowledge it with a nice little, back in my day, it was a stamp that they would put there and say like, we acknowledge the PO, but just for the sake of letting you know that we received your order, but it's based on our terms and conditions. And the supplier was so sneaky that they would add it at the end in their little blurb saying that it's still based on our terms, right? And then unless I, as an employee at the time, as a buyer, would bring that up to the legal counsel, I could think, nope, it's a done deal. It's good. We're good to go. The PO is in place. And then if it's not because of an issue that arises, people would find out later on that no, that acknowledgement that we provided to your PO said that it's based on our terms. So again, I think it's a lot about education, a lot about corporate culture, about processes and procedures, and making sure, again, to draft proper contracts.
Great, thank you. Teresa's got a question here. I think I would be more interested to specifically AI, Gen AI related service contracts, and what clauses should we look for? So I gather, would there be a specific clause related to an AI generated contract?
So let's see if I understand. Is the question regarding the use of AI to develop service contracts?
I think I would be more interested to specifically to AI, Gen AI related service contracts, and what clauses should we look out for? Okay.
Okay.
Teresa, could you explain your question a little bit further, please?
Hi there. I'm just interested to see like the type of service that would be contracted for AI specifically, not the use of AI to create contracts. I don't know if that makes any sense. Like if a company decides to onboard a vendor that has AI features, does that make sense?
Oh, I see what you're saying. Okay.
Yeah.
Yes. So thanks again, Teresa, for the question. I think it's a little bit of everything. So I recently was in a process of selecting and getting an approval for a CLM platform in my office. So I went through the same ordeal of finding a platform that met the requirements, and specifically as it related to AI capabilities, like how is that handled? Like where is my information going? Like what type of server is that handled? Like in a server outside of Canada? Like is the information getting anonymized and like just leveraged into the same platform, and all the derivative rights that come out of that, are they leveraging that? Like there was a lot of concerns about the IP aspect of it. Like how much should you be disclosing in any of these AI tools when it comes to just getting a quick answer, right? So I do think there's a need to find out where your information is going, to understand what their confidentiality terms look like. Also, even if you just use them like on a one-time basis or ongoing, understand like what's going to happen once you stop using that platform. Is the information going to be kept in some sort of form forever and ever? Is it something that you're going to be able to control down the road? So I'd be very concerned about just getting a better sense of where that information is going, and what resources or recourse do I have if I don't want to share my private or proprietary information just for the sake of getting a response.
Thank you.
Thanks, Teresa. There are 5 or 6 comments here, Andrew. Just thanking you for the presentation, the information, very informative, as the comments are indicating. Much appreciated. Any final questions before we close off, guys? You can see here. Take a moment to connect with Andrew on LinkedIn. We will be sharing the presentation. We did mention that earlier. We'll give you a copy of the presentation. Also, we will post the video for you on our YouTube channel. Please do check out the YouTube channel, future postings that we'll be doing as well. And then also please follow us on LinkedIn. Please connect with Andrew if you can. Andrew, any final comments before we close off?
Thanks, Manley. Yes, please connect with me if you have any follow-up questions. I'd be more than happy to answer them, as long as they're just general in the sense that I'm not providing any legal advice. And as it relates to contracts, as I said, it might not be the sexiest part of the overall supply chain process, but it's the part that determines what happens when things go wrong. So it's definitely worthwhile taking the time to make sure that it's done right the first time. Like one of the quality principles, I can't remember the name, but there's a quality principle that talks about that, just doing things right from the get-go.
Okay. And for those of you based in Calgary, most likely you've seen Andrew at some of our events. So check it out. We do have another event coming up May 14th. There's only 10 seats left. So if you want to come out and network, definitely a great event to do. You'll see in Calgary, we're doing a lot of different things, right? There'll be a couple more sessions coming up later in the year as well. Also, for those in the Vancouver area, we do have a summit coming up in mid-October. So again, thank you very much, Andrew. Great topic, by the way. Very informative. You just supported a couple things that I had actually been had gone through as well. So you pretty much said exactly what the lawyer said to me. So it was excellent. Again, thanks everybody for attending. Much appreciated. Look out for more different sessions that we hold. But we do welcome the questions and as well the participation. Thanks again, everybody. Have a good day. Have a good weekend.
Thank
you.
you.